Welcome to This Explainer. Today, we're unpacking a really fascinating legal tug-of-war. It's the clash between a judge's absolute duty to hear a case and the absolute necessity for them to remain completely impartial. It's kind of crazy to think about, but this is one of the most foundational, yet totally unresolved tensions in modern law. Let's get right into it.
Imagine for a second you're a judge tasked with deciding a massive, high-stakes constitutional case. Recently, Chief Justice of India's Surya Kant, and before him, Justice Sanjeev Khanna, actually stepped away from huge petitions challenging the new Election Commissioners Act. Now, you might be wondering, why do judges voluntarily walk away from these monumental, history-making cases? And on the flip side, why do some absolutely refuse to step down when they are directly asked to?
Well, here is our roadmap for figuring this out. We'll start with the judge's dilemma, then compare recusal versus the duty to sit. After that, we'll trace the origins and legal frameworks, dive into the Indian constitutional perspective, and finally look at solving the recusal crisis. Starting right off with Section 1, the judge's dilemma. You see, there is just immense pressure on the judiciary to maintain institutional integrity, but also unshakable fairness. The dilemma they face is very real. Think about it. If a judge steps down too easily every time things get tricky, the whole system just grinds to a halt. Litigants could essentially pick their judges. But if a judge stays on a case where they genuinely have a conflict, well, the public completely loses faith in the very concept of justice. It is an incredibly delicate balance. That brings us to Section 2, recusal versus the duty to sit. First up, we have the doctrine of recusal. This is rooted in an old Latin maxim, Nemo judex in causa sua, which essentially means no one should be a judge in their own cause. Basically, it's the voluntary withdrawal of a judge because they have some sort of conflict of interest. The absolute core objective here is to make absolutely sure that justice isn't just done behind closed doors, but is visibly, manifestly seen to be done by the public. But, immediately countering that, we have the duty to sit. When judges take their oath, it implies a profound, literal obligation to sit and actually hear the cases assigned to them. This doctrine demands that judicial officers resist the urge to just recuse themselves because a case is controversial or difficult. It has to be there to prevent litigants from strategically judge shopping and effectively crippling the court system. So as you can see, these two doctrines are really warring sides of the exact same coin. Recusal protects fairness and the crucial appearance of impartiality, while the duty to sit protects the actual institutional function of the court. They both absolutely exist to protect justice, but they achieve it by pulling the judge in two completely opposite directions. Let's move to Section 3, origins and legal frameworks. Where do these conflicting ideas actually come from? Historically speaking, the common law heavily favored the judge staying on the case. Way back in 1668, English courts literally ruled that favor shall not be presumed in a judge. Basically, trust the judge. Fast forward to 1964, and the U.S. Fifth Circuit explicitly laid out a really strong duty to sit. But then things took a major turn. By 1974, following some massive high-profile controversies, the U.S. Congress actually stepped in. They amended the U.S. Code to legally mandate recusal if a judge's impartiality might reasonably be questioned. So this objective standard became a direct legislative strike against the old duty to sit in federal courts. Now, notice the stark contrast here between the U.S. and India. While the U.S. has these codified, written-down statutory rules that require recusal based on an objective standard, the Indian framework relies almost entirely on unwritten convention, past precedents, and ultimately an individual judge's personal conscience. In the U.S., the reasoning for stepping down is fully documented. But in India, it's often oral, totally undisclosed, or the judge might just remain completely silent on why they left. Which perfectly leads us into Section 4, the Indian constitutional perspective. In India, the legal battleground often looks a little something like this. On one side, you have the mandate for fairness and fundamental equality under Articles 14 and 21 of the Constitution. But that frequently collides head-on with the Third Schedule. The Third Schedule contains the constitutional oath of office, which explicitly demands that judges perform their duties without fear or favor, affection, or ill will. This exact tension was brilliantly captured by Justice J.S.K. Hard during the massive Sahara and NJAC cases. He actually weaponized the duty to sit and that very constitutional oath to repel strategic, calculated recusal pleas. His argument was powerful. He said that stepping away simply because a litigant asked him to would actually be a direct violation of his sworn oath to the Constitution. Let's look a bit closer at that monumental NJAC case from 2015. Litigants practically demanded Justice Kahar recuse himself because he was part of the collegium, the existing system where judges appoint other judges, which was exactly what the new law was trying to replace. But the court pushed back, ruling that this wasn't a personal conflict. It was an institutional conflict shared by literally every single Supreme Court judge. So one judge stepping down wouldn't cure the bias at all, it would just pass the buck. In this scenario, the duty to sit absolutely prevailed. However, here's the catch. Relying purely on an unwritten honor code leads to some pretty massive inconsistencies. Take the recent Delhi liquor policy cases. You have the exact same set of facts, but two different judges reacted in completely opposite ways. Justice Swaranakanta Sharma firmly refused a recusal plea, boldly stating it has to stem from law, not just a public narrative. But then, just months later, Justice Sanjay Kumar recused himself from a highly connected case without giving a single reason at all. And the crazy part? Both of those actions are completely legally valid under the current Indian system. This just brilliantly illustrates the severe vulnerability of relying entirely on a judge's conscience.
So let's wrap this up in Section 5, Solving the Recusal Crisis. If a judge's conscience is doing way too much unsupervised heavy lifting, what are the solutions? Well, the sources lay out 4 very clear reforms. Number 1, statutory codification. We need to draft objective, written standards for exactly when a judge must step down. Number 2, mandatory disclosure, creating a convention where judges actually have to provide a written explanation for recusing. Number 3 is establishing a formal, strictly enforceable code of conduct. And number 4, putting neutral master of the roster protocols in place. That way, if a Chief Justice does have to recuse themselves, their replacement is assigned transparently, not just arbitrarily.
I want to leave you to ponder this final question. Until the judiciary steps up and provides real codified transparency, will every single recusal dispute just be fought out in the court of public opinion? This delicate balance between the duty to sit and the duty to recuse is literally the bedrock of a fair legal system. But without clear rules, that bedrock is just resting on the very fragile shoulders of individual discretion. Thank you so much for joining me for this explainer, and remember to always keep questioning the frameworks that shape our world.